Getting a last little bit of lunch there?
Yes.
All right, looks healthy.
It's all fine.
Okay, good afternoon, everyone. We are live from courtroom 1D for our afternoon jail calendar, Zoom jail calendar. We are live on YouTube as well, so that folks who want to can follow along and hear and see what we're doing. I will take the lead from my colleagues there in courtroom number 2. What order are we going to go in, folks?
Your Honor, we're going to start off with position number 4, Mr. Krupe.
Okay. My understanding is that position 1 will not be joining us. Is that correct?
That is correct, Your Honor. He's on quarantine.
Okay, but everyone else will get in whatever order you tell us.
That is correct, but also position number 7 is he's not in our custody. He was released.
Oh, okay. 7 that's Mr. Carter?
That is correct.
All right. And why did you decide to let him go? Just kidding. Okay, so we'll skip number 1 and hope he gets well. We'll start with number 4 and I'll just follow your lead. So position number 4 is Mr. Krupe. Can you hear me, Mr. Krupe?
Yes, Your Honor.
Great. You are represented by Mr. Collins. I see Mr. Collins on the screen there. Good afternoon, Mr. Collins.
Good afternoon, Your Honor.
And I believe that Ms. McCauley is going to be handling all of these cases for the state. Thank you, Ms. McCauley, for filling in for your colleague, Ms. Hall. Let me get my hands on the petition here. All right, Mr. Collins, so I can decide what we're going to do from our end. Is this a contested hearing, or is this one where your client is admitting to the allegations?
Unfortunately, Your Honor, I don't think we can contest it. He was convicted in Cobb County.
Okay.
So
Then let me tell Mr. Krupe where I think we are, and then I'm going to get a little information from our probation officer. I don't see her on the call. Ms. Nelson, do you know if Ms. Crawford is joining us again? Ms. Nelson, are you there?
I can't unmute.
Now you're here. I'm not seeing anyone from probation on our call.
Okay, let me see if I can find Ms. Crawford.
Okay. So, Mr. Krupe, I'm Judge McBurney, and I am handling your revocation. The allegation is that in almost a year ago, in January of last year, you committed a burglary in Cobb County, and you were a little bit behind in your fines. I will tell you that not paying your fines is really not why we're here. The bigger deal is it sounds like you may have gotten in trouble again. You pled to a burglary here in Fulton County, and then while on probation for that burglary, there was a new one in Cobb County. And I think that's why folks are concerned and what we need to work through. Ms. McCauley, is this something you've negotiated with Mr. Collins, or are we going to?
Yes, it is, Your Honor. I believe, if I'm not mistaken, that Mr. Krupe only has 5 months and 6 days left. And he has been in custody for 10 months. He was in custody in Cobb County previously. The state would be seeking to revoke the balance entirely and then just commute it to the time that he served in Fulton County.
I want to make sure I follow that. So if I revoke the balance, but you would have that clock start retroactively.
Correct. Yeah.
Okay. Mr. Collins, your thoughts?
just to be clear, and I want to make sure I'm clear as well, what we're talking about is revoking, but giving him credit for time served where he already was, correct? So he would be
Yeah.
releasing.
It's exactly what you emailed me, Sean.
That's what I now understand Ms. McCauley to be saying, Mr. Collins, that her recommendation is that I revoke all the remaining balance of your client's probation, but give him credit from basically when he went into custody, which is double that amount of time. So he served the revocation time. Now, whether he gets out or not depends on whether he's got holds elsewhere, if Cobb is looking to see him, et cetera. But Fulton, or at least this case in Fulton, would not be holding your client in custody.
Understood, Your Honor. And yes, Ms. McCauley and I did speak about that in that regard.
Okay. Well, tell me a little bit about your client and what's going on with back-to-back burglaries and why I shouldn't be worried that we're going to see a third burglary in a few months.
Well, so really these both incidents stem from a serious substance abuse problem, which he was trying to attack him and his mother. I believe his mother is here, and I asked to maybe have her testify. I don't think we're going to need that, but she is here in support. And what led to the last burglary was him going to county services for his addiction issue. He was turned away, stating that they did not have the resources to provide to him what he needed. And so they gave him a medication, Suboxone, I believe, which is a opiate withdrawal medication. And while he still was trying to get over it, I believe a friend of his, and there was a mistake on Mr. Krupe's part, took some more medication to try and even himself out based on how the medication was making him feel. And what ended up happening was a blackout period to where in the sense of a burglary, I understand the definition per the OCGA, but what ended up happening is somebody went into a neighbor's house and put their furniture and whatnot in the driveway. So nobody ever actually took anything and tried to sell it or any of that. We're not looking at a hardened criminal here, Your Honor. We're looking at an issue of substance abuse, and it needs to be dealt with the proper channels, through the proper channels, I should say.
Okay, and what are the plans to get that? All makes sense. And I think part of the point of my question was, what are we lining up to ensure that Mr. Krupe gets the care that he needs? So that's the deeper question. The predicate question is, when you say county services, your client was trying to get help in Cobb County, That's correct. Okay.
Yes, Your Honor. He had actually had his probation transferred from Fulton to Cobb because that's where he moved.
Okay.
His mother and Cobb, I believe they were supposed to. Miss Krupe, are you here with us today? Can you hear me?
Yes, I can hear you.
Okay. I don't know if you wanted to swear in, Judge, but what exactly do we have in place for Mr. Krupe when he is released? I know he's getting back into school, but if you would explain to the judge what we have in place.
I have, there's some local places where he can continue his NA meetings. I am also, and I can't do so until Nicholas is out, set him up with new insurance. The insurance that he had, he won't be able to continue because of having a felony on his record, which is unfortunate because it offered the better care for him. But he will be able to go into the marketplace, and I already have a addiction specialist / psychiatrist that has assisted us previously, but he has a dual capacity to be able to assist Nicholas if we need to continue down that path. And I've also got some other things lined up that I'm hoping will make a huge difference for him. And of course, having been off of anything for the last 11 months has been a significant help for him. So, we'll have to cross that bridge with the psychiatrist when we meet with him.
Thank you, Ms. Krupe. I would like to add, Your Honor, the condition, his sentence in Cobb County was 10 years probation. So he will continue to be on probation and be actively monitored.
Did you handle Mr. Krupe's Cobb case, Mr. Collins?
No, Your Honor, I did not, but I did download the sentence and I'm happy to provide it to the court.
No, I'm not doubting you that you say it's 10 years probation. I'm trying to sort out why the part of that probation wasn't drug court or treatment or something along those lines. It just seems like we're coming late to the process of getting treatment for your client.
I believe, Your Honor, these things were supposed to happen in Fulton. And based on a failure of probation services, they may not have occurred. Ms. Krupe can also fill us in on exactly what took place with the probation in Fulton County.
Yeah, so originally he was with Probation Officer Williams, and we reached out to her first in August. And then she was supposed to come and have a home meeting with Nicholas first, but we didn't see her. And I reached out to her again in September and said, hey, we're about to move. What do we need to do for the transfer process? We went through the steps of the transfer process to Cobb County. We were aligned with Ms. Edwards as his probation officer. I reached out to her in October. I reached out to her again and again, September all the way through January. She needed to do that home meeting with him before she would get him started on anything with any of the documents so that he can continue with the NA meetings documented, as well as the, I guess the 40 hours of community service. I wanted to get started on that during Christmas. I thought it would be a good opportunity. She said to wait until she met with him in person. And even as of a couple of days before his arrest, we had never seen her.
What do you, Ms. Krupe, do you know what the terms of, and I'm trying to look it up right now. Do you know what the terms of the current probation in Cobb County are? What the stipulations are?
Well, he was supposed to continue with the NA meetings or AA meetings. He was supposed to do 40 hours of community service, and I believe that was it. But again, we had never seen her to get anything started, and we had to have that piece, and she continued to make me wait.
Well, let's be careful here. You guys may need to be a little more proactive then in terms of you being made to wait, et cetera. We want probation to pitch in where they can. But if there are issues, you should reach out to Mr. Collins so that he can try to contact Department of Community Supervision, their phone numbers to call. But being passive, saying, well, I'm waiting on them, that's not going to play out real well in the long run. If Mr. Krupe has 9 more years of probation in Cobb, I'd like that to go as smoothly as possible for him.
Yes. Yes,
Mr. Krupe,
I did actively communicate by text with her.
Okay, well, good. Mr. Krupe, what's your drug of choice? What were you struggling with at the time these kinds of things were happening?
Opiates and benzodiazepines.
Okay, and when you say opiates, that's a broad category. Was there something in particular you tried to get your hands on?
Heroin.
Okay, hence the Suboxone. Okay. Well, that's scary stuff. I hope that, as your mom observed, 10 years being away from it will help. I mean, 10 months being away from it since you've been in custody. But, you know, the temptation is out there. So I hope that through a program you can get involved with or assistance you may get from probation out of Cobb, you'll be able to stay on the side of this that you are trying to stay on. How old are you?
I'm 20, Your Honor.
Okay. This was a first offender disposition in Fulton. Is it now officially a felony in Cobb?
Yes, I was charged with a felony in Cobb.
Okay. So you now have a felony record too. And as your mom has already observed, that's made it more complicated for you to get help and for you to try to move in the direction you want to go. So you're going to want to be all the more committed to trying to get this right going forward. We have been joined by our help from probation. Ms. Crawford, how are you doing?
Hey, Judge, I'm doing fine. I apologize. I had internet problems.
No worries. I appreciate you joining us. We're talking about position 4 on the calendar, Mr. Krupe. And the recommendation, which I'm going to follow, is to revoke the balance, but we wanted to confirm with you what the official balance is in Mr. Krupe's case.
He has 5 months and 6 days remaining on his case.
All right. So in light of the conviction for burglary in Cobb County, I'm going to revoke the balance, but I'll give Mr. Krupe credit from June 1 of 2020. So he obviously served 5 months and 6 days. That will close out his Fulton County case. He's well aware that he has many years of probation remaining in that Cobb case. And our hope is that he can get some effective treatment while he is in Cobb. Mr. Krupe, will you be living at the Nuthatch Court address when you get out?
Yes, Your Honor.
Okay. Ms. Krupe, is that your home?
That's correct.
Okay. And your son can stay with you for now?
Yes.
Okay. All right. Ms. Crawford, do you need to give Mr. Krupe reporting instructions, or what do we need to do with that?
If his case here in Fulton is going to be closed out, then he won't have reporting instructions with us.
Okay.
He's going to report. Yes, he's going to report to, I think, is it Cobb County?
It's Cobb.
He's going to report to Cobb.
Okay. Mr. Krupe, do you know where that is, where probation is located in Cobb, or do you need that information?
Yes, Your Honor. I believe my mother has it, but I could find it easily myself.
Okay. All right. So what's your plan? Are you going to try to work when you get out, or what? Are you going back to school?
Yes, Your Honor. My plan is to go back to school and be involved in NA. I'm quite hopeful, actually.
When you say back to school, where would back to be?
The hope is that I'm going to be going to Cobb Horizon to finish out the remaining credits that I have for my diploma, and then hopefully to enroll in college.
Okay. So you don't have a GED yet?
No, Your Honor.
All right. Well, first things first. Good luck with that. Ms. McCauley, anything else in Mr. Krupe's case?
Nothing from the state. Thank you, Judge.
Mr. Collins?
Nothing further, Your Honor.
All right. Well, Mr. Krupe and Ms. Krupe, good luck with everything. I hope that you're able to turn the tide on this one.
Thank you, Your Honor.
Thank you.
Thank you,
All
Your
right.
Honor. Excused.
Yep.
Thank you, sir.
Next to be position number 2.
Is that pronounced Coley?
Yes, sir.
All right. Good afternoon, Mr. Coley. How are you?
Fine.
Good. Mr. Coley, you're on the calendar for a probation revocation. Your lawyer, Ms. Patel, is on this call as well. Hopefully you can see her. Ms. Patel, are these contested allegations, or is Mr. Coley admitting to or stipulating to the allegations?
He is stipulating none.
Okay. So we're all set on this end. Why don't you then, Ms. McCauley, let me know what the state is recommending.
Yes. Okay, hold on just a second. Your Honor, which position is this?
Pardon me?
Which defendant is this? Is this Mr. Coley?
Yeah, number 2.
Okay. So the agreement is to revoke 150 days and continue on probation. I think he has 2 years, 2 months, and 8 days left. And I think that he pre-trial came off his bond on his new case, so we should be good to go.
The new case is still a CP case?
Correct.
All right. The notes here say battery. Is that going to be as it looks, a felony, or it's just sitting out there?
I think it's sitting out there. I think that there's a note in here saying that it might be transferred, but we're not sure yet.
Okay. And the revoking 150 days, is that giving Mr. Coley credit for time served, or that's a prospective 150 days?
That is giving him credit for the time that he has served.
Okay. And Ms. Patel, when did Mr. Coley sort of ballparkish, when did he get arrested?
In August, Your Honor, so he's been in for 145 days.
Okay.
5 extra days.
Right.
Got it. So he wouldn't get out today, he'd get out in about a week.
He's not going to get out because he doesn't have a bond on his new charge.
The CP case. Okay.
Correct.
Oh, right. I think I saw that.
Pretrial came off the bond. It's converted to a straight bond, but the bond is like $20,000.
Okay. I'm looking. It's a 10. Yeah, I don't know how that works when pretrial comes off it, but I don't need to get in the middle of it. Okay. All right. So the basis for the revocation is the conduct underlying this CP case. And Mr. Coley is stipulating to a basis for this revocation.
Correct.
Got it. All right. Mr. Coley, when you understand what we're doing here today?
Yes, sir.
So you've got these new charges, and that's what's going to be keeping you in custody if you stay in jail after about a week from now. And you will be figuring out what happens with those new charges. But this older case, you'll still have probation on it, but that warrant won't be a reason for you to be in custody. So if you figure out bond on these new charges, then you'll be able to, I think you'll be able to get out if you don't have any other holes. Does that make sense?
Yes, sir.
Okay. I have an address for you that is an apartment on Old Hateville Road, but it's a condition of your bond that you have no contact at all with the person who is the alleged victim in your new charges. Does that person live at that apartment?
Yes, sir.
So you understand you'd need to go somewhere else?
Yes, sir.
Okay, where would that be?
My mother's address.
Okay, and does your mom live near Old Hateville Road or somewhere else?
Somewhere else.
What town?
She still lives in Fulton County.
Okay. What part of the county?
South.
Okay, but just not near Old Hateville Road.
No, sir.
Okay. All right. Ms. Crawford, how much time does remain on Mr. Coley's case?
Judge, Mr. Coley has 2 years, 2 months, and 8 days remaining, and we'll also need an address for him.
Okay. So, Mr. Coley, if you do figure out bond on your new charges and get out, where is it that you'll be? I know you said your mom's place. What's that address?
143 Hillsdale, HILLSDALE Drive.
All right. You have a zip?
30315.
All right. And is it 143 or 543? 143. 143 Hillsdale Drive in Atlanta, 30315.
Yes, sir.
Okay. Ms. Crawford, do you need to give him any reporting instructions, or we don't know necessarily that he's getting out?
We don't know that he's getting out, so I won't give him any.
Okay. All right. So, Mr. Coley, in light of your stipulation that you got arrested for these new charges, I will revoke 150 days of your probation. You will get credit from the day. What day? Do you remember when you got arrested? I heard it was August, but do you remember the day?
August 13th.
Okay.
It was August 12th, 2020.
All right. So you'll get credit from August 12 of 2020. It sounds like that's not quite 150 days ago, but the sheriff is free to decide that you've done enough of the 150 days. It may be you spend a few more days. But as both your lawyer and the prosecutor pointed out, that clock may end, but you'll still be stuck there until you figure out bond on your new charges, okay?
Yes, sir.
All right, Ms. Patel, anything else on Mr. Coley's case?
No, Your Honor.
Ms. McCauley?
No, Your Honor.
All right, thank you, Mr. Coley.
Next is gonna be position number 6.
6. Hello, Ms. Snyder.
Afternoon, Judge.
Happy New Year. And there is Mr. Walker. Hello, Mr. Walker. Can you hear me, Mr. Walker?
Yes, I can hear you. How you doing today, sir?
I'm doing okay. I can hear you now too. So, Mr. Walker, your case is on our calendar for what we call a final plea discussion. And in theory, if Ms. Snyder, your lawyer, has received all the discovery in your case, et cetera, you ought to be in a position to say, I've worked it out, or I don't like what the state is offering me, and I'd like my case to go to trial. But I have to hear from your lawyer where we are in that process. So, Ms. Snyder, what's going on in Mr. Walker's case?
Your Honor, I have all the discovery. You signed an order for me to go out and see him in November. But with the holidays and then with me getting sick, I have not had a chance to go see him and show him the videos and discuss the case with him. So I would ask for a reset. I have not yet been cleared to go back into my office. So I don't have my computer or his file, excuse me, or anything.
Okay. You feeling better?
Mostly.
Mostly. All right. 2020 wasn't a great year for you on that front.
No, sir.
So I'm just looking at the indictment here. So there's video evidence that you need to share with Mr. Walker. That's the importance of the two of you being in the same place.
Yes, sir. It's dash cam and body cam.
Okay, got it. Have you received an offer from the state?
I did. Ms. Hall gave me an offer yesterday. I think she had given me an offer the last time we were on the final plea calendar based on her grid criteria, but she did give me an offer again yesterday.
Okay, what kind of criteria?
I think just their grid.
Oh, like a sentencing grid that the district attorney's office has. Okay, so you have that information to share with Mr. Walker as well. But you need to get with him, and that's not going to happen in the near term.
I'm not sure when they're going to let me come back in the building.
Okay. So how far out should we set this? Honestly, Judge, I don't know. Well, you're the one asking for it. So what I'd love to avoid dragging Mr. Walker into court or getting him on the screen again just to reset it again. So I'm happy to give you time to do the important things that you need to do. But as I understand your situation, the math is there. They need to be letting you back in the building soon enough. But that doesn't mean that you necessarily get out to the jail right away, et cetera. Do we put this in February? Do we put it in March? Obviously, Mr. Walker wants to see you sooner, but it needs to be safe for you, it needs to be safe for him, et cetera.
February should be fine.
Okay. Mr. Walker, you have a question?
Excuse me, Your Honor. Is there any way I can hear what if y'all had claimed with a plea deal, is there any way I could have heard it before she came to see me?
Yeah, I mean, she can tell you right now. It's not secret. I don't know what it is. I don't get in the middle of the negotiations. So it may be that Ms. Snyder wants to talk to you about it where you can react in a way that the prosecutor's not sitting right there. But I'll leave that up to Ms. Snyder since you two can see and hear each other right now. But most importantly, Mr. Walker, I want to make sure we set up a time for you and Ms. Snyder to meet. And if that proves complicated out at the jail, then Ms. Snyder, we also have as a fallback the reverse commute, as we've done before, if we need to do it that way. All right. So do you want to tell Mr. Walker whatever the offer is now, or how do you want to manage that?
Would you mind putting us in a breakout room?
I don't mind that. We'll do that. And then, Mr. Walker, I'm going to put you, you don't have to move anywhere. The deputy's going to have to push some button on the screen there. But you and Ms. Snyder are going to be in a place that's private. I can't hear you. The prosecutor can't hear you. So you can say, praise the Lord, or something else when you hear what the state's offer is. I'm going to not let you guys talk for too long because I need to get the jail's focus back on whoever's next on the calendar, but we'll put you there for a couple minutes, okay? Hold on. All right, they're in the breakout room.
You want to move to another position, or you want to wait for them to come out the break?
No, if you guys have the facility to move to another position, let's do it. I wasn't sure if you were having to do that thing where people run around the jail with the same camera.
We still do have to run around, but I'm ready. I done ran already.
You already ran. Amen. Who do we got now?
We got position number 3, Mr. Matthew Lamorris James.
Great. Thank you. There he is. Hello, Mr. James.
Hey, how you doing today, sir?
I'm doing well. Mr. Franklin has joined us. I hope you can see him on the screen there.
Okay.
Great. Mr. Franklin, Mr. James is, in his petition, it is alleged that he committed a couple new offenses. It looked like maybe one in March and one in September of this past year. Where are we? The notes I have is that it got continued once because your client was in the hospital, Grady, and then maybe these charges were going to be contested. So that may be why it's back on the calendar. What's your understanding of what's happening today?
Yeah, he was in the hospital in Grady. He has, I'm going to say this incorrectly, psychodosis. He essentially has a scar on his heart. His heart doesn't beat normally. And I know he's in the process of, I guess, pretty soon getting a defibrillator to address that issue. I spoke with Ms. McCauley earlier today. I made mention of the September incident. Hearing what you just mentioned, I did not make mention to her of the March incident, which I believe to be a misdemeanor. So I'm not sure if that changes the agreement that we had. So I'll give her a moment to hop back on and let me know. But otherwise, we had an agreement to address his probation today.
Okay.
And that would have given him, I didn't have a chance to convey this to Mr. James yet, but it would be to continue him on his probation.
Okay. Well, let's see what Ms. McCauley has to say.
Yes, Judge. So the defendant's been in jail for 120 days. If it wasn't contested, we would probably just move to revoke 120 days and continue him on probation. And if it is contested, then we'll go forward with a formal hearing.
Okay. I'm hearing Mr. Franklin say not contested because he's okay with 120 days. Is that more or less what?
That's the agreement.
Okay. Okay. Is it the same victim in the two matters, the March and the September?
No, I think it's different.
I know
Okay.
that
Correct in saying that,
I know the
Devin?
September. I'm sorry. The September incident I know is a separate individual than the probation incident. I can't recall if the March incident is the same person or not.
I'll just double check. Hold on. I feel like I want to say it's different, but I don't want to be wrong. So let me check first. Of course, my Odyssey decided not to work on my laptop.
Yeah, same. There it is.
Okay. It is. I think it's a 17 too.
I'm sorry, say it again.
It's a 17 too. That's the same nature of offense.
Okay.
Okay, it's Miss Arnold in the 18. No, it's a different victim. That's what I thought. It's Miss Cunningham, Iceland Cunningham in the 20 case.
So there are 220 cases. It's Ms. Cunningham in both of them?
No, I have the 20 CP 193 case.
Yep.
The showing is an Iceland Cunningham
Okay.
is the victim. 2018 case is a Korea Arnold.
Right. I'm looking at that one. That's the one for which we've got the petition.
Yeah. Are you asking about the?
So what I'm asking about, the petition
You're asking about the
alleges.
state court case. Hold on.
Yeah. So I never saw the petition. I was just able to print up some documents that were attached to his booking.
Yeah, I'm not able to pull up the petition either. But I can see that his state court case, let me see if I can pull the victim in that one. Sometimes it lets me, sometimes I'm locked out. It's the same victim in the state court case in March.
Meaning it's Cunningham?
It's Iceland Cunningham, yes.
Okay. All right. So, Mr. Franklin, are you aware of anything else holding Mr. James in custody? Does he have a bond on the CP case?
On the CP case, he does not have a bond. I know that he would be interested in waiving indictment if we were able to get to an agreement on that case.
Okay.
But this was all kind of a last minute conversation with Ms. McCauley. And I know she tends to look into the background of it more when it comes to actually resolving a new case. So I didn't approach her about that today.
Okay.
When it comes to DB cases.
Okay. So the revocation would not get Mr. James out. It would just get this warrant off of him. And then he would still need to sort out what's going to happen with the CP case.
That's correct. I was going to reach back out afterwards and see if it was something that we could reach a agreement on and waive indictment to get him out.
Okay. Ms. Crawford, how much time remains on the 18 SC case for Mr. James?
There's 11 months and 8 days remaining.
All right. Mr. James, who is Ms. Arnold to you? Do you have kids together? Was she a significant other? What was the connection?
There's no connection. Here's someone that I sold a TV to. I don't even think her name is Miss Arnold. Well, it's been so long, but I don't even know the lady.
I represented Mr. James on the case involving Ms. Arnold. Essentially, both Mr. James and Ms. Cunningham were accused of being involved in an altercation with Miss Arnold, whatever her real name may be.
Okay.
And Mr. James is the one who was accused of, I guess, actually offering physical violence in that case. But as I recall, we resolved it on lesser grounds.
Okay.
Terrorist threat and something else.
Got it. So this makes more sense because Ms. Cunningham is listed as a witness in this, and it looks like she was a neighbor of Ms. Arnold, slightly different apartment at MLK. But now Ms. Cunningham is a name that I'm recognizing because she is the victim in the older case. And because this case, the 18 SC case, doesn't have anything to do with domestic violence. It's whatever beef was had between Cunningham, Ms. Arnold, and Mr. James. But the more recent conduct that you may resolve, short of indictment, Mr. Franklin, that is alleged mistreatment of Ms. Cunningham. That's the domestic violence.
That's correct. And she's the mother of his child.
Got it. Okay. Mr. James, we've been doing a lot of talking. Do you follow everything we've been saying? You have any questions about it?
No, I was trying to correct you guys, but y'all got it together.
Well, dang, you should have spoke up. You could have saved us 15 minutes.
I was raising my hand. I didn't want to be rude and just talk.
All right, I'm sorry. Well, we got it straight now. I should have looked up a little bit more about the charges in this 18 SC case. They are what they are. All right, what I'm going to do is follow this joint recommendation, Mr. James, and revoke 120 days of your probation in light of your arrests in these two matters in March and in September of last year. You're not admitting to that conduct, but you were arrested, and that's a basis to revoke. I'll revoke 120 days, and I'll give you credit. How long have you been in?
It's 118
days. 118 today.
Okay. Do you recall when it was you went in?
September 9th.
Say again? September
9th.
Okay. So I'll give you credit from September 9th. And you're not, when that 120 days is up, that's not going to suddenly be the jail doors open and you get out. You're going to need to sort out, and it may be Mr. Franklin helps you with this, what's going to happen with these unindicted charges. Okay. Does that make sense?
Yes, sir.
Any questions about that? Anything else we got wrong?
Mr. Franklin, I'm going to talk to him about the indictment situation.
Yeah, that's a conversation I have to have with Ms. McCauley after court.
All right.
I wasn't able to get documents to her to verify stuff that I know she's going to need me to verify beforehand.
Okay.
I'll be in touch.
All right. You good, Mr. James?
Yes, sir.
All right. Thank you. Oh, before you go, don't go. Stay right there. Ms. Crawford, we need to verify an address.
He has new pending charges that he has to face, correct?
Can you say that again?
Does he has other charges, correct?
Yeah, he's not getting out right away.
That's correct. So I don't need to verify.
Okay. All right. I just need to make sure. All right. Thank you, Mr. James.
We can go back to 6.
Okay. So, Ms. Snyder, you and Mr. Walker had a chance to talk?
Yes, sir.
All right. Anything else we need to cover?
Not today.
All right. You will let Ms. Nelson know if I need to enter any other orders that will help you connect with Mr. Walker so that he can see and hear the evidence that you have?
Yes, sir.
Okay. We'll reset this to some date in February for either a plea, if you guys are working it out, or the final plea discussion that we need to have. Okay?
Yes, sir.
All right. Mr. Walker, you all right?
Yes, sir.
Okay. Ms. Snyder is going to connect with you soon.
All right, appreciate it.
All right. Thanks. So, Mr. Franklin, position 7 is yours. He's not in custody anymore. Ms. Nelson said he might show up here. He has not shown up here. We're not quite done with the calendar, but have you heard from him since he got out? Did you know he got out? You're on mute right now.
He was out at the time that we had that court date.
Okay, so he's been out. I don't know how he ended up on this calendar, but Ms. Nelson, was this a notice calendar for Mr. Carter, or did we think he was in custody?
Judge, I knew that he was out. I just added him because we had a couple other final pleas on the calendar. I can reset it for another calendar where everyone is aware that he will walk in.
Okay, but we have Mr. Franklin, you believe we've got good contact information for him?
I need to find it on a different calendar. I think when I got his contact information, I didn't write it in my file. I wrote it on a separate calendar. So I need to find that and try to reach him that way.
Okay, well, we'll reset it, but it will be with the assumption that he comes to court unless you tell us he's gonna dial in.
Yes, sir.
All right, then by process of elimination, this should be number 5.
That is correct, Your Honor. Position number 5, Mr. Morgan.
Hey, Mr. Morgan.
Hello.
How are you doing?
I'm okay.
Okay, well, okay is better than not okay. Mr. Morgan, your lawyer, Ms. Snyder, is on the call. You can see her in one of those squares in front of you. I'm going to have her tell you and me what's going on with your case. Today was supposed to be the day where we figure out if you've worked a case out or if I should move it to a trial calendar. But as you know well, these are complicated times and sometimes we haven't been able to line everything up. How are we doing with Mr. Morgan's case, Ms. Snyder?
Your Honor, I do have all the discovery and I have an offer from the state on this, but it's the same situation. I would ask for a reset because I don't have his file with me and have not been able to get it.
So basically your work world is not available to you other than what's online because you're not allowed to go in the office.
Yes, sir. The one day I don't take my computer home, the next day I get sick.
Okay, all right. Have you and Mr. Morgan spoken recently? Is this news to him or what's going on there?
We've not. I've not been able to speak to him.
Okay. What I'm going to do is put you and Mr. Morgan in a breakout room so you can have a couple seconds just to get him up to speed, and then we'll reset this. This one sounds like it can be a briefer reset because you don't need to work through some of the same things that you needed to with your other client. Is that a fair statement?
Yes, sir.
Okay. Mr. Morgan, hold on one sec. I'm going to put you in a private room with Ms. Snyder, okay?
Yes, sir.
So, Mr. Morgan, I don't know if there's, here comes someone. Great. We'll see you in a little bit. I think that's it for everyone else. Ms. McCauley, if you do not have an objection to Mr. Morgan's case being bumped a few weeks down for another final plea, you can get to the many other things I'm sure you're supposed to be dealing with.
Thank you, Judge. I appreciate it. Have a good day.
All right, you too. Mr. Franklin, same deal. You're welcome to stay on, but I think we're finished with all your cases.
Yes, sir. Thank you.
And I'll be leaving too, Judge.
All right. Bye, Ms. Patel.
Take care.
And Ms. Crawford, you're free to go too if you want. We'll be all by ourselves here.
Okay, thank you. Have a good day. I'll see you all tomorrow morning.
Okay, bye-bye.
Judge, who's handling the Wingo plea?
Oh, I forgot all about the Wingo plea. I guess we need to get Macaulay back, eh?
Okay, I'll reach out to her.
Yeah, and Miss Crawford shouldn't go anywhere.
I was just gonna try to hurry up and get off.
Yeah, nice try. You owe us a few minutes anyway.
That's right.
Wingo. We're not quite ready for him because we need his lawyer to get here, but as soon as he gets here, we should be good to go.
And he's coming in.
I believe so. I'm going to ask Ms. Nelson's trying to get the prosecutor back on the call. I just excused her, but I believe we were waiting for the lawyer to come on in through those doors. Hey, Ms. Snyder.
Hey, Judge.
Did you and Mr. Morgan talk about what you needed to cover?
We did. I relayed the offer and let him know that as soon as I'm able to get back into my office and get his file, that I will set up a call with him so we can discuss what we should do.
Okay. Mr. Morgan, we're just letting Ms. Snyder get a little bit better in terms of health, and then she'll be able to get back into the office. She and you will talk, and then we'll reconvene and cover what we were going to cover today, okay?
All right, can y'all tell me when I will be back in court? How long will it take?
My guess is it would be 2 or 3 weeks. We can't do anything until it's safe for Ms. Snyder to get out of the house and get back to work. Once that is true, she can get her file and get in touch with you, and we might be able to move it even faster than that. But I want to build in enough time so that we don't get you back on the screen like this only to say, hey, Ms. Snyder's still not able to have that conversation with you. So I would guess towards the end of January. Okay?
Okay,
We'll see you then.
thanks a lot.
You're welcome.
I think that's all I have on this side, Your Honor.
I think you did well. Appreciate it.
Not a problem. You're welcome.
We'll see you in a few weeks.
Yes, sir.
Well, Ms. Snyder, you keep getting well and keep us posted as to when you can get back in your office, okay?
Yes, sir. Thank you.
All right, bye-bye.
All right, bye.
Ms. Nelson, do you know, is Mr. Bowles planning on coming in here, or was he going to dial in?
I was under the impression he was coming to the courthouse. I just sent him an email to confirm, but I was under the impression he was coming to the courthouse.
Okay. Well, we have his client here, not in the courtroom, but in the holding area. So if you can just give us an update, were you able to reach Ms. Macaulay?
No, I just sent her a text message. I guess I can give her a call on her cell.
Okay. Well,
okay, thanks.
Let us know what you hear.
Okay, thanks.
Thanks. So we're on for 2:30. That clock is wrong. So in a half hour, prosecutor will be back on, and that's when the defense attorney is going to be here. So I'll come back out. If they get here before then, let me know. But otherwise, I'll be back out in about a half hour. Thanks. Oh, yeah. Nobody's here.
I was just writing Deedra to ask her if we heard from some polls yet. Asked Deedra if she heard from Mr. Bowles. She says, no, I have not. He has 4 minutes.
Good. Hello. Happy New Year.
Good afternoon. Happy New
Good
Year.
afternoon. You have a good break?
Yeah, it's been decent. You know, I can't do much.
Well, but sometimes not doing much is okay.
Well, that is true.
You don't need to fill, I know normally there's a long plea form. We'll just cover everything through the colloquy that Ms. McCauley will, unless you would prefer to have a plea form filled out. I just think it's simpler in this era to have fewer pieces of paper bopping around.
Mr. Bowles, if your client is going to sit at the microphone, you might want to stand at the podium so the mic will pick you up. Okay. Actually, yeah, we should put on purpose. Oh, no. All right, like I said, we got 10 to do 8 for all cases. So you can complete your cases with Fulton County. I don't think you got anything else anyway. You just want to go over your rights. I'm gonna ask him for first offender. I don't know if you're gonna give it because it is two of these are all robberies. All we can do is ask.
Yeah, what about like you guys before? Can you mandate like what they call community rehabilitation work leave, like a halfway house?
He can't do that. The board of pardons and paroles have to do that. He can't do that because this is a mandatory. You know, when we renegotiated, I got them to specially agree to come down off the 10 and do 8 and give you less probation because I don't think you really need to be on probation too long. So it's only 2 years probation, but there's only a limited amount of things you can do with this. But I am going to ask the first.
What about they ain't gonna come down no more?
Huh?
They ain't gonna come down no more.
No.
I didn't do that. Go take a trial. Then I'm gonna ask you about my feet. How you pointing up and they should. I know anybody gonna take too much away from me.
Well, he said that he knew you from jail. That I know. I don't have the thing. I gave it to you.
I left that.
Okay. Yeah, he said he knew who you were. Yeah, that's what he said.
Mr. Bowles, you guys ready, or do you want a little more time?
Just a couple of minutes, Judge.
Okay.
What about you? I'm not saying one more thing. So you think if I go to trial, it ain't gonna look good?
No.
Just because but it just did my work.
But it's also they pointed you out. They can prove that y'all was in the jail at the same time, and you was in his car a day later. It's too many coincidences. Ain't nobody going for that shit. He pointed you out and you in his car. If you wasn't in his car, that'd be one thing.
So he was fired day by day. The rest of it.
Yeah. Well, probably a little less than that, a few months less than that, but close to the whole 5. But if you ain't doing 10, you ain't doing 15. Ready to go?
Yeah.
All right, Judge, we're ready.
All right. Mr. Forte, are you ready?
Ready, Judge.
Turn my screen back on. Okay. Good afternoon, Ms. McCauley. I mistakenly released you for the day. I appreciate you returning.
It's okay, Judge. I actually knew that there was this hearing today. I just had another, I had a task force meeting I had to go to, so I just zoomed into that so I could zoom back out.
Good. Lots of zooming. Appreciate it. Well, I think we are ready to proceed with a plea. Is it in all 3 cases?
It is in all 3 cases. Correct me if I'm wrong, Mr. Bowles, but that is correct. All 3 cases.
That's correct. It's all 3 cases.
It is. And Mr. Bowles, for Ms. McCauley to be able to hear you, you should be at one of the microphones. It's probably best for Mr. Wingo to stay where he is, right in front of that microphone. But if at any point the 2 of you need to speak, you and your client, feel free to go back to the table. If you need to speak in confidence, we'll need to have it be away from that microphone because whatever Mr. Wingo says now, it's going to go through that microphone, not only to the prosecutor and everyone else, but YouTube is running right now because this is a live public proceeding.
Okay, Judge.
Okay. But it is my understanding that Mr. Wingo is prepared to enter. Is it a negotiated plea?
It is.
It is negotiated, Your Honor.
To all 3 cases. Is that your understanding, Mr. Wingo?
Yes, sir.
Okay. Well, for us to do that, you need to be put under oath by Ms. McCauley. That's the prosecutor you see on the screen. that may be a less familiar face for you. You have been not working with, but the prosecutor who has been working on your case for a number of months has been Ms. Hall. She's a colleague of Ms. McCauley's, and while I won't call them interchangeable, it's okay for one prosecutor to fill in for another. They all represent the state. The real special relationship is you and your lawyer. We can't have just someone random come in and sit as your lawyer. So you and Mr. Bowles have been working on this for a while. He's right here in court with you. So you're in court, open court. Ms. McCauley is not all that far away. She's in the DA's office in an adjacent building, but she's going to handle the prosecution side, okay?
All right. Yes, sir.
In a moment, she's going to put you under oath. Once you're under oath, it's important that you answer all of her questions and mine. We're both going to have questions truthfully and completely. So if at any point someone says to you something, asks you something that you don't understand, it's not what you expect because Mr. Bowles said, hey, it's going to go this way and it goes that way. You need to let me or Mr. Bowles know so we can make sure you are comfortable with what's going on and you understand what's going on. Will you do that?
Yes, sir.
Okay. No one's going to intentionally trip you up, but again, you and Mr. Bowles may have discussed how things are going to work. And if they turn in a different direction, you're entitled to talk to Mr. Bowles about that and say, wait a minute, that's not what I thought was going on. And we may have just misspoken, and that's the source of the confusion, but you need to let us know, okay?
All right.
All right. It's also important that you answer, you don't need to yell, but make sure you're speaking in the microphone because Mr. Forte needs to make a good record of what we're doing here today. All right?
Yes, sir.
Sounds good. Okay, Ms. McCauley, when you're ready.
Yes. All right, Mr. Wingo, could you please raise your right hand? Do you swear and affirm that the testimony you were to provide is the truth, the whole truth, and nothing but the truth to help you under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Could you please state and spell your name for the court?
K-Y-N-T-E, Kente. My last name, Wingo, W-I-N-G-O.
All right, Mr. Wingo, how old are you?
I'm 22 years old.
How far have you gone in school?
I got my GED.
All right. Can you read, write, and understand the English language?
Yes, ma'am.
All right. If at any point there's anything that I say that is confusing, go ahead and ask me and tell me that it's confusing and ask me to explain it further, okay?
Yes, ma'am.
All right. And are you satisfied with the representation of your attorney?
Yes, ma'am.
At this time, do you need any more time to speak with him?
No, ma'am.
All right. Are you under the influence of any substance or medication that would prevent you from fully understanding what you're doing here today?
No, ma'am.
Is there any medication you normally take that you've not had today?
No, ma'am.
Okay. And is it your understanding that you are entering a negotiated guilty plea to the following three cases? And I'm going to start with the case that ends in 797, which is theft by receiving stolen property, carrying a weapon without a valid license, obstruction of a law enforcement officer, misdemeanor possession of marijuana, abandonment of certain drugs. And that sentence is going to be 5 years to serve on the theft by receiving stolen property. I'm sorry. Yeah, the theft by receiving stolen property. The carrying a weapon without a license, that will be 12 months to serve. And all the other misdemeanors will also be 12 months to serve. So the only felony is that theft by receiving. You understand that that is going to run concurrent to your other charges. Is that your understanding?
Yes, ma'am.
All right. Let's move to the next case, which is the co-defendant case. And that case number ends in 178, and the charges are as follows: hijacking a motor vehicle in the first degree, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and armed robbery. And the recommendation or negotiated plea that you've entered into on that count is for, on the hijacking a motor vehicle, the aggravated assault, and the armed robbery, you're entering a plea to 10 years to serve 8, with the balance to be probated. And that's being entered pursuant to 1710, I think it's 6.1 subsection E, which says that the state is agreeing to let you plead to less than the mandatory minimum on that charge of armed robbery. And then that possession of a firearm during a commission of a felony, that's going to be 5 years suspended, and that's going to follow all other charges. So it's a 15 to serve 8, but you're only going to be on probation for those 2 years that follow that 8-year sentence of incarceration. Do you understand that, Mr. Wingo?
Yes, ma'am.
All right. And that's going to run at the same time as that other case, that theft by receiving stolen property. And then I'm moving to the last case, which is 18 SC 159921, which the charges are as follows: possession of a firearm during the commission of a felony, armed robbery, hijacking a motor vehicle, and aggravated assault with a deadly weapon. That is a case in which you are charged as the sole defendant. And the negotiated plea on that case is for the armed robbery, the hijacking a motor vehicle, and the aggravated assault for 10 years to serve 8 years, consistent with 1710 6.1e. The state is agreeing to the defendant serving a sentence less than the mandatory minimum on the charge of armed robbery. And on that possession of firearm during the commission of felony, that's going to be 5 years suspended, the same as the other case. So it's really a sentence of 15 to serve 8, but you're only going to be on active probation for those 2 years after that 8-year period of incarceration. All of those cases are going to run at the same time, and that's the negotiated agreement. Mr. Wingo, is that your understanding?
Yes, ma'am.
All right. Have any questions about any of those sentences?
No, ma'am.
All right. Do you understand that if you are not a United States citizen, a conviction in any of these cases would have a negative impact on your immigration or visa status?
Yes, ma'am.
Did anyone force, threaten, or otherwise make you enter into a guilty plea?
No, ma'am.
Do you understand that by entering into this guilty plea, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to have the evidence against you proved beyond a reasonable doubt. You have the right to confront and cross-examine the state's witnesses, as well as any other evidence presented against you. You have the right to subpoena your own witnesses to come to court and testify in your own behalf. You have the right to be represented by an attorney at that trial. If you cannot afford to hire your own attorney, you may have one appointed to you at no expense. And should you be convicted, you would have the right to appeal that conviction with the assistance of an attorney. Do you understand those rights, Mr. Wingo?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up those rights?
Yes, ma'am.
Do you understand that if you are sentenced to any term of confinement, neither the state nor the court, nor probation, nor your attorney has any impact on when you will be eligible for parole? That decision is solely made by the Department of Community Supervision and the Department of Board of Pardons and Paroles and the Department of Corrections. Do you understand that?
Yes, ma'am.
Do you understand that this conviction can be used against you in the future as use of evidence in a similar case for a future crime, for impeachment of your testimony, or to enhance a future criminal sentence?
Yes, ma'am.
All right, Mr. Wingo, you are pleading to armed robbery, which will be a conviction on your criminal history. If you were to get a subsequent conviction, which is also considered a serious violent felony, which is one of homicide, murder, aggravated child molestation, aggravated sexual battery, rape, kidnapping with bodily injury, another armed robbery. I'm missing one. You would be sentenced as a serious violent offender under 1710(7) subsection B, which has other sentencing ramifications. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you have any open cases, suspended sentences, or are currently serving on any term of probation or parole in any jurisdiction, including federal court, a conviction in this case would have a negative impact on those sentences?
Yes, ma'am.
And do you understand that the terms of the negotiated plea as previously described?
Yes, ma'am.
All right. And as to the charges, and I will go back through them again, Mr. Wingo, and I'll start with the case ending 18 SC 159921, possession of a firearm during the commission of a felony, armed robbery, hijacking a motor vehicle, and aggravated assault. How do you plead?
Guilty.
Thank you. And as to the case 18 SC 159921, charges as follows: armed robbery, hijacking a motor vehicle, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. How do you plead?
Guilty.
And to the last case, 18 SC 159178, 18 SC 797 charges is theft by receiving stolen property, carrying a weapon without a valid license, obstruction of a law enforcement officer, possession of marijuana less than 1 ounce, abandonment of certain dangerous drugs. How do you plead?
Guilty.
Do you enter these pleas knowingly, willingly, freely, intelligently, and voluntarily with the full facts and knowledge of the case before you?
Yes, ma'am.
All right. Thank you very much. Your Honor, if these cases were to proceed to trial, state would show as follows, and just give me one moment. Judge, I got to go back to my notes. I will begin with the case in which Mr. Wingo is the sole defendant for the armed robbery. That incident occurred on June 10th of 2018. Officer Buhler with the Atlanta Police Department responded to a 911 call involving a carjacking. Mr. Buhler spoke with the victim, Xavier Thompson. Mr. Thompson stated that that the accused, who was subsequently identified, drove up behind him while he was standing outside of his car. Mr. Wingo, are you okay?
Yes, ma'am.
Okay. All right. Just want to make sure I wasn't interrupting conversation and taking away from the proceeding. That's okay. That a black male later identified as the defendant drove up behind him while he was standing outside the car. The defendant was accompanied by an unknown male in a Nissan Pathfinder. The defendant approached the victim, pointed a pistol at the victim, and demanded money to give him his property, which contained a wallet, including his bank cards, iPhone, keys, and the BMW 2013 328i. The victim actually recognized the defendant from when they were both in custody at the Fulton County Jail. The victim also identified the defendant out of a photo lineup that was presented by Investigator Towns. Officer Thomas subsequently received an LPR hit for the stolen BMW, and he proceeded in the direction of that hit and spotted the defendant running from another officer and was subsequently captured. At that point, that incident took place at 46 Daniel Street Southeast, which is located in the city of Atlanta in Fulton County. And I'm moving to the next case, Your Honor, which is the co-defendant armed robbery.
Okay, just so the record's clear, you just gave a factual basis for the indictment ending in 921.
Correct.
You're now turning to the indictment ending in 178.
Thank you, Judge. Yes. It's a little confusing trying to keep all of these organized.
No doubt.
On June 10th, officers responded to 3400 Norman Berry Drive, which is located in the city of East Point in Fulton County. Officers spoke with the victim, Chris Potts, who stated that on that particular day, he was walking to his 2011 Infiniti QX56 at the location, which happens to be the Doubletree Hotel, when he observed two males crouched down on the rear fence of the property. Mr. Potts stated that one of the males was wearing a red Cincinnati Reds jersey. Potts stated the two males approached him, pointed a black handgun at him, and stated, "You know what's up, give me the keys." Potts stated he gave them the car keys, and both males drove off in his vehicle. On the 11th of June, APD officers observed Potts' vehicle and attempted to pull the vehicle over. The vehicle sped up and struck a UPS truck, injuring the postal worker in the collision. The driver of the vehicle was Mr. Wingo's co-defendant, Quindarius Jones, and two other individuals were inside the vehicle and were arrested. Defendant Jones, the driver of Infiniti, was wearing a replica gold Rolex watch, which belonged to the victim, Mr. Potts. On that same day, officers observed the stolen red BMW, which had been stolen in a carjacking. Upon stopping the vehicle, the defendant, the driver of the BMW, and another individual fled the vehicle, later arrested. Fleming, the passenger in the Infiniti, provided details of the carjacking involving Mr. Potts and claimed Mr. Jones was responsible. Mr. Jones, in turn, implicated Mr. Wingo in the theft of the Infiniti and stated that he was the fourth individual involved in that case, and that they had been on a crime spree earlier that particular day. I'm now moving to the last case, which is 18 SC 159797. If I can find it. That incident occurred on Tuesday, April 10th of 2018. Officer Klickner with and Officer Young with the East Point Police Department were in the area of 3887 Washington Road, which is located in the city of East Point in Fulton County. Is the location of the Washington Road Food Mart, where they identified a individual known as the defendant in front of the store on top of a cooler, speaking with customers as they arrived, and then subsequently left the store. Those officers proceeded to turn into the parking lot, at which point the defendant jumped off the cooler and began walking away from the store. Officer Klickner exited the vehicle and gave him a command to stop. He slowly started to turn back around, then suddenly took flight through the parking lot and through the wooded trail leading towards Laurel Ridge Drive. As he ran, the defendant was observed discarding several items out of his hoodie into the wood line. As he reached Laurel Ridge, Officer Klickner and Officer Young were able to apprehend him and put him into handcuffs. They subsequently brought out a K-9 to assist in locating the items, at which point the defendant admitted that he had a possession of weed. I'm sorry, Your Honor, I'm trying to read my notes and they're a little fuzzy. For some reason, my computer is not showing it. And then also found in his possession was a firearm that had been reported stolen out of a neighboring jurisdiction. He was seen trying to discard that weapon as he ran along the wood line, and that is the basis for the theft by receiving stolen property.
Okay. So tell me why only 2 years supervision, and given that this is a plea not to one carjacking, but two, you are seeking to invoke 6.1E.
Correct. So on this second armed robbery that involves the co-defendant, there's not a secret. That case is not the strongest case. It requires the compliance and involvement of the co-defendant in order to secure a conviction. Factually, it puts the state in an interesting position. However, the indictment, I believe it's ending in 178, that is the single defendant armed robbery. The state has had many discussions with Mr. Bowles about what would be an appropriate sentence in this particular case. Given Mr. Wingo's age, and as I can speak freely from reviewing his criminal history with Ms. Hall several weeks ago, as well as reviewing his dependency history in the juvenile courts, the defendant has not had a particularly enjoyable childhood to adulthood. He has been in and out of juvenile court in delinquency and deprivation cases. Given his age, I think the sentence is appropriate. He's very young. This will at least give him an opportunity to get out while he is still very young, and not continue to be in and out of custody as he has spent the majority of his life thus far. The victim in the single defendant armed robbery has been a little difficult. So I think that this plea and these negotiations are in the best interest of the state. As to the amount of supervision, Your Honor, I understand the possession of a firearm during the commission of a felony is a suspended sentence that does follow this case. The state could seek to revoke that should Mr. Wingo catch another or pick up another case during that interim amount of time, which will hopefully not happen. However, I don't know if a more lengthy probation sentence would be useful in this particular case, and I'll leave that to the discretion of the court.
Okay. And my understanding is that the co-defendant in the case ending in 178, that's Mr. Jones, is not a fugitive. He has a lawyer, but he's on bond. And so there hasn't been the same pressure to move that case because Mr. Jones hasn't been sitting in jail for however many days Mr. Wingo has been.
Yes, and it's my understanding Mr. Wingo has been in custody the entire time.
Yep, that's my understanding too. Okay, thank you. Ms. Crawford, do you have any adult criminal history for Mr. Wingo beyond these three cases?
No, Judge, no record found for Mr. Wingo.
Okay. Ms. McCauley, you mentioned that you've had an opportunity to review Mr. Wingo's juvenile history and that there were dependency hearings, delinquency hearings, et cetera. Did you find anything that was along the lines of the armed robberies and carjackings in reviewing the juvenile history?
To be candid, yes, I did. He has a 2014 adjudication from juvenile court that is in a criminal attempt to commit armed robbery. I did not get an opportunity to review the police report for that because it has been removed from the system in accordance with their record sealing procedures. He does have some other minor juvenile court adjudications, but that was the only felony. And again, that was from 2014.
Okay, thank you.
Mhm.
Ms. Rolak, do you have any victim impact information from either Mr. Potts or Mr. Thompson? And Happy New Year to you.
Happy New Year, Judge, and I hope you guys can hear me. I am unable to use my camera. I'm not sure why. But yes, I have had the opportunity to speak both with Mr. Chris Potts, who is following the YouTube live feed, and also Mr. Xavier Thompson. Mr. Potts just wanted to let you know that he didn't want to make a statement, a written statement, but he wanted to let you know that he and his family were leaving Atlanta to go back home. They had attended a wedding, and when this incident happened, and he was really scared for his family at the time of the incident. But he wanted to, he said that he just hopes that the defendant turns his life around.
Okay, well, I appreciate that. That is a helpful perspective from Mr. Potts, and hopefully he and his family have, in some respects, been able to move on. And it sounds like his family didn't personally experience the carjacking. It was Mr. Potts who was the victim, not just in the technical or financial sense, but in the personal sense.
Yes, and he also reports that that it was really just about the car and not necessarily about them.
Okay, all right, thank you. And nothing in particular from Mr. Thompson?
Mr. Thompson declined to cooperate with our office.
Okay. Ms. McCauley, is there any restitution that we need to be working through, or that's not how these cases are being resolved?
That's not how these cases are being resolved. I don't believe that there's any outstanding restitution.
Okay. What's your understanding, Ms. McCauley, about parole eligibility for a sentence to an armed robbery count that is reduced pursuant to 6.1E?
So it's my understanding that the parole eligibility does not change, even though it is a reduction under the mandatory minimum, that it is a day-for-day sentence. I believe there is some policy of the Department of Boards of Pardons and Paroles that the last year may be served in a transitional housing, like the facility off of Ponce. But it's my understanding that's day-for-day time.
Okay, so it's different from changing it, reducing it from armed robbery to robbery, and then saying 15 to serve 8. The 8 is an actual 8. It just 6.1E lets the two sides recommend something less than 10.
Correct.
Mr. Bowles, is that your understanding?
That is my understanding, Judge.
Okay. Tell me what you would like to share about Mr. Wingo and these 3 cases. And as you're thinking about your comments, I'm not particularly concerned about the 797 case, the running in the wood line with the, you might have won that one anyway. So obviously the scary ones are pulling a gun on someone and taking his or her car.
Right. Well, Judge, to be frank, there's really no excuse for the behavior, except for the fact that Mr. Wingo, as has been said, has spent a considerable amount of time in custody. And unfortunately, when he got out, he got with individuals who did not help him become a better person. Each case involves somebody else. The case that was first called out for trial for the 11th involves somebody else who was driving the car that dropped him off. The other case involves a few individuals actually who actually were caught later in the car. it's just a situation, Judge, of it's been a little tough for him. His father was ill and did pass a couple of years ago. So now it's just him, his mother, and his sister. Unfortunately, Mr. Wingo just chose the wrong path and chose the wrong friends, and led to these incidents. I've explained to him how dangerously close he came to possibly spending the rest of his life in prison. These two armed robbery cases carry a maximum life sentences. And when you talk about two, then it's much more likely that you're getting closer to that. And at a minimum, after a trial, I told him you're looking at 15, 20 years, easy. And as I explained to him, I felt that the case with the BMW 921 is a solid case for the state. The other case, but and I love a challenge, but I'm rolling the dice with your life, not mine. So that case could have went either way, I believe. But 921, I do not feel good about at all. And I explained that to him. And I appreciate Ms. McCauley working with me to come down to a sentence that I think he can live with and still get out and be an extremely young man. He does have his GED, Judge. So normally I would say, go acquire that. But I would encourage him to enter some type of work program when he gets, and actually he has asked me about that. And I told him, Your Honor, really didn't have the power to change the last year to a work release type thing. But as Ms. McCauley stated, that last year could be likely could be in a transitional facility where they might actually have him working. But that is up to Board of Pardons and Paroles, and the judge does not have that power in this situation. So other than that, Judge, well, let me add this. This is not part of the agreement. Ms. McCauley did not agree to this. I did discuss it with Ms. Hall. She did not respond, but I did have to ask for first offender. His youth is of concern to me because he has a full life ahead of him. And when he gets out, he'll still be in his late 20s. And well, actually, yeah, mid-late 20s. And I think that, I don't want to say give him a chance because I think he's had chances, but not since everything has accumulated together, because he's been in jail really because both cases came down at the same time when he got arrested in the BMW.
Sounds like they were just a day apart.
Yeah, they were very close in time. And so he's been in jail since then. He's been in jail for almost 3 years, like 2.5 years. And I would like, with these on his record, it's going to make things even tougher for him when he gets out. And I know Your Honor looks at this and is very concerned. That's just the reality of life. You're looking at 2 armed robberies, 2 carjackings here. But I am asking for him to receive treatment under first offender. I've explained the good and the bad, the good being that, hey, when you get out, if you successfully complete probation, you won't be a convicted felon. The bad, however, and there's a lot of bad with this because of the high range of sentencing that the court has before him. But if he messes up, he can be resentenced and he can receive anything up to life twice because there are 2 armed robberies. So if he messes up on first offender, the consequences are severe. And the court will not even have to go through the problems of going through a trial. They can just change your sentence. But I do want to see this young man succeed. He does have a support system, his mom, his sister, and I would like to see him be able to succeed. I know Ms. McCauley probably has a different position on this, and I definitely respect that. But I am asking that he be treated under the first offender statute.
Okay.
I don't necessarily have a different position, Your Honor. I don't believe that he's eligible for first offender with a conviction for armed robbery. I don't think the first offender applies to any serious violent felony.
I think that's right. I was trying to look that up. I got distracted by merger question. But let me look that up because that makes it moot either way. What's the code?
I think it's 17. I think it's 1710 6.1. It should be in the annotations. And it actually might be sometimes it's in the annotations, sometimes it's in the sentencing provisions of the actual charge itself. Hold on, I'll go look it up. Because I know on the sex cases, it says that they're, like you're subject to.
No, you're correct. It's here. It is the same statute that provides the relief that Mr. Wingo is seeking also bars that request. 1710 6.1 B Bravo 3, B3 says no person convicted of a serious violent felony shall be sentenced as a first offender pursuant to, and it references the statutory provisions for first offenders.
I'm sorry, Judge. I think you might have skipped over it. Did you say that I was right?
I'm sorry, there's a lot of static in the line. I can't hear you.
I've looked that up as well, Judge, and Ms. McCauley is correct. Because it's an armed robbery charge, he's not eligible for first offender.
I understand the basis for the request and appreciate it. It's not an option here. I do want to talk about merger. I think that the aggravated assaults in the two carjacking cases merge into the armed robberies. I know the armed robberies and the carjackings do not merge. The statute says that, but I think the way these crimes have been described and the way they're alleged, that they really ought not, it's not going to change anything, but we'll get a legally correct sentence. I don't think there should be a sentence for count 3 in the case ending in 178 and count 3 for the case ending in 921. Do you agree with that, Mr. Bowles?
I do agree with that, Judge.
Ms. McCauley?
I agree with that too, Judge.
Okay. And I'll try to remember to say that. Mr. Wingo, I got a couple questions for you. And then if there's something you want to add, you have a right to say whatever you want to say right now. Your GED, did you get that while you've been at Rice Street or did you get it before you went in?
Juvenile.
In juvenile. Were you at a YDC when you got it?
Yes, sir.
How long were you at YDC's?
2 years.
Non-stop or in and out?
No, non-stop. Just 2 years straight.
For what?
Burglary and attempt to armed rob.
Okay. The kind of thing that I heard Ms. McCauley talk about?
Yes, sir.
And your father passed away while you were in custody on these charges or before you went in on these?
On these charges.
Okay. Was that someone you had spent, was he an active presence in your life? Did you know him well?
Yes, sir.
Okay. It sounds like you still have your mom around and you have a sister around.
Yes, sir.
Okay. How old's your sister?
I got multiple sisters.
You got lots of sisters. Okay. Are you the youngest, the oldest, or somewhere in the middle?
In the middle.
Okay. All right. Anything you want to share with me?
No, sir.
All right. Well, congrats on the GED, and I'm sorry about the passing of your father. Mr. Bowles, do you waive any legal issues that might arise? I can't think of any that might arise from the fact that we are proceeding with copies of the 3 indictments.
So waived, Judge.
Mr. Wingo, I find there's a factual basis for your 3 pleas, meaning based on what Ms. McCauley has told me about the case, if in fact the state proved all that, a reasonable jury could find you guilty. Would they? I don't know, but they could, and that would be a rational decision. I understand Mr. Bowles' perspective that in the case ending in 178, what we've been calling the co-defendant carjacking, even though they both were, Mr. Bowles may have some pretty good legal issues to throw at the jury, and he might have some good suppression issues in the stolen gun case. But staring you in the face is the BMW carjacking case where it sounds like there's not as much legal wiggle room. But either way, if the state could present all the evidence that Ms. McCauley shared with me, I think they'd establish a factual basis. I also find that your plea to each of the 3 cases is knowing and voluntary. A knowing plea means that you've understood everything we've been talking about, or if you didn't, then you let Mr. Bowles know and he explained it to your satisfaction. Is that a fair statement?
Yes, sir.
Do you have any questions about anything we've discussed so far?
No, sir.
A voluntary plea is simply one where no one's forced you to enter the plea. You're probably not excited to be sitting where you're sitting right now, but you are there because you, after consulting with Mr. Bowles and maybe talking with your mom or one of your sisters, have decided that this is the best way forward for you. Is that true?
Yes, sir.
Okay. Then I'm going to accept your pleas in all 3 cases. In 2 of the cases, you're going to be on probation for a little bit, and I'm sentencing you in those 2 cases pursuant to what's called the Probation Options Management Act. And all that means is that while you're on probation, if you have a problem, you violate some rule of probation, and it's a minor one, like you miss a meeting or you change addresses and you don't tell them about it up front, you and probation will work that out. You'll only come back to see me or some judge if you have caught new charges. That would be a violation of probation. That's going to get you back in front of a judge. But for technical things, you and probation will work through that. Now, Mr. Wingo, I believe he preserved his final plea rights because we weren't able to. Where are we in that process? I mean, this case predates me by many years. And
Right. We had final plea, I believe, in front of Judge Reader.
okay. And what did that mean in her courtroom?
It's just been going on to the trial calendar.
Well, I didn't ask that well. In my courtroom, if a case is not resolved by final plea, there can be a negotiated plea later. That's fine. But the defendant does not have the right to withdraw the plea if the judge sentences other than what's negotiated.
To be honest, Judge, I can't remember her policy.
Okay.
Final plea.
Well, how about this? I'm going to tell you what your overall sentence is going to be. It's a little different than what we've talked about, and I'll explain why. And then Mr. Bowles, you and Mr. Wingo can huddle up for a minute to decide whether he wants to go forward or if he wants to go to trial.
Okay.
And I'll break it down into smaller pieces, case by case, but effectively the sentence is going to be 12 years to serve 9 years with that balance probated. There's still a 5-year suspended sentence afterwards. So technically, it's 17 to serve 9, but it's 9 years to serve, a little bit more than what was negotiated. And I'll explain why in a minute. 3 years probation, not 2. I'll explain why in a minute. And then that same suspended piece. We can't make that go away. That's going to be out there.
Right.
And I'll work backwards. I think an additional year of probation is helpful because we haven't really seen what life is like for you, Mr. Wingo, when you're an adult and you're not in jail. And I think a little longer period of, we call it supervision, but it's also support because probation can help you with job readiness and looking for employment and things like that. They're not just making sure you're staying out of trouble, but they can be support as well. But it is a way for folks to keep in touch with you to make sure that you are trying out something different when you get out. And I think that additional year would be helpful. And I'll tell you, if you are doing fine on probation, probation is not up in your business. They are bugging you only if you're testing positive with a drug screen or you're not showing up for meetings or they can't find you when they're trying to find you. Then they're all over you. But if you're doing well, if you're working, doing your own thing, it may just be, you call in once a month or something like that. The time to serve. I appreciate why the state has agreed to invoke 6.1E to get you below the 10 years. I'm not sure I would go there, but I'm less close to the facts than your lawyer and Ms. Hall and Ms. McCauley. And I trust very much Mr. Bowles and his reasonableness and Ms. Hall and Ms. McCauley's. And if they think it's appropriate to get below that 10, then I guess we're going to get there. But because of the fact that we're dealing with not one, but 2 carjackings, and I appreciate that one may be harder to prove, but it doesn't sound like it would be hard to prove you were in the mix. And layer on top of that, even though Mr. Bowles has pointed to the fact that, hey, look, he's got no adult criminal history. You were barely an adult when, as we define it legally, when this stuff happened. I mean, that was 3 years ago. So you're 19, you're 18, you just become legally an adult. So you wouldn't have an adult criminal history. But we know from your juvenile history that you were mixed up in stuff that got you 2 years in a YDC, which is a pretty significant sentence on the juvenile side. And so I worry that actually, for reasons that aren't necessarily your fault, and I appreciate folks haven't gone into the details, that you had a pretty crummy childhood and times were not easy for you, but you got involved in enough things that there actually is a little bit of a history of you making decisions that endanger other people and frankly endanger you. I'm worried about you as well. We live in a society where you pull a gun on someone and say, give me your car, and the person pulls out a bigger gun on you and says, no, give me your gun. And who knows who's going to get shot when something bad happens. So, you know, this was real serious stuff. What separates your cases from the life sentences is no one pulled the trigger in one of these cases, but that's about as serious as it gets. So I appreciate that you're young, but given the confluence of all these cases and what I heard about how your older juvenile years were spent, I think it you know, a straight 10 years is probably appropriate, but I want to sort of meet halfway and acknowledge that the state was going so far as to invoke the 6.1E. So again, I'm happy to break this down count by count, but I don't need to do that if the answer is going to be no way. Two important things. One, whatever sentence I say, you're going to get credit for all the time you've been in. So you've already bankrolled 2.5, almost 3 years. Two, I will certainly recommend in each of the 3 sentences that you be considered for, it's not called early release, but transitional housing, work release, something like that, along the lines of what you talked to Mr. Bowles about. That recommendation helps, but it's a recommendation. My ability to control the outcome of your case ends once I sign that sentencing sheet, and it's really up to the Department of Corrections. But I'll tell you, you control it even better than I do. If you are doing well while you are at whatever facility you're at, they're going to want to get you to a place where you can get ready for the transition. If you're in prison and you're making trouble, they'll have no incentive to get you to a place like that. So you'll be able to control your destiny to a certain extent. But I wanted you to know I'll certainly recommend that. Do you have any questions about how I'm envisioning this sentence before, Mr. Bowles, you speak with your client?
No.
Okay. Tell me what you want to do. You can sit there, but everyone can hear because of the way the microphone works.
Maybe if we could just step right there.
Do you mind that?
No.
Okay, great. You guys mind if we just have Mr. Bowles and his client stand right over there? Thanks.
We're going to go ahead and proceed, and Mr. Wingo is going to accept the court's sentence.
Okay, then let me pronounce those by, I'm going to go in numerical order of the indictment, excuse me. So the first one numerically is 18 SC 159178, which is the Infinity carjacking with Mr. Jones as a co-defendant. And your sentence as to count 1 will be 12 years to serve 9 years with the balance on probation. And that sentence is pursuant to OCGA 1710 6.1E. And the record should be clear that the state has agreed to the invocation of that statutory provision. Count 2 will be the very same sentence. It'll run concurrently. Count 3 merges with count 2, and count 4 is 5 years. It will run consecutive to count 1, and it is suspended. The next indictment in numerical order is 18 SC 159797. That's the stolen gun case. And the sentences to count 1 is 5 years to serve. Counts 2 through 5 are all 12 months to serve. All those counts run concurrently with each other. And this case, 797, runs concurrently with 178. Finally, the case ending in 921, 18 SC 159921. This is the BMW carjacking case. The sentences to count 1 is 12 years to serve 9 years with the balance on probation. And this also is pursuant to 1710 6.1E. Count 2 is the same sentence. Count 3 merges with count 1, For some reason, armed robbery comes first in this indictment. Anyway, it merges with count 1. And then count 4 is 5 years. It runs consecutive to count 1, and it's suspended. And the sentence in 921 runs concurrently to the sentence in 178. And so the record is clear. Whatever the ultimate final dispositions say, they should reflect a term of 9 years in custody, followed by 3 years on probation, and then 5 years suspended. And each of the 3 final dispositions should indicate that Mr. Wingo gets credit for time served as determined by the custodian, because I think it's an arrest date. He hasn't been in or out, in and out. There's just Mr. Wingo went in and he's been there nonstop. I will recommend, and I'll put this in the magic box on the final disposition, that Mr. Wingo be considered for a transitional program, work release, whatever the Department of Corrections may be calling it at that time, assuming Mr. Wingo is eligible for it, meaning you're doing well while you're in custody, staying out of trouble, taking classes, stuff like that. The last thing I have is a question for each of you. Mr. Wingo, in normal times, we pass lots of papers around and you'd be signing a bunch of things. You need to sign each of the 3 indictments indicating your plea of guilty. Do you authorize me to sign on your behalf?
Yes, sir.
Okay. Mr. Bowles, can I sign for you?
Yes, Your Honor.
And Ms. McCauley, may I sign for you?
Yes, of course. Thank you, Your Honor.
All right. Mr. Bowles, anything else we need to cover in Mr. Wingo's 3 cases?
I think we've covered it, Judge.
Okay. Ms. Nelson is reminding me, and I forecast this, but I forgot to say it. 178 and 921, those are the 2 cases with probation. They will be sentenced pursuant to the Probation Options Management Act for the reasons I explained. Ms. McCauley, anything else in Mr. Wingo's 3 cases?
Nothing from the state. Thank you.
Okay. Mr. Wingo, I know you have a ways to go. My hope for you, you'll have forgotten me by the time you get out, but my hope for you is that when you emerge and are plugging back into family and friends, you spend a little time, 1, appreciating being out, and 2, thinking about who your friends are going to be, because it does sound like you were flowing with the wrong crowd back in June of 2018, and you see what's happened. You don't get those years back, but you will still be a young man with a lot ahead of you when you get out. I just hope you are in a position to make different choices, okay?
Mhm.
Good luck with everything.
Thank you, Judge.
Thank you, Mr. Bowles. So that gets you off the trial calendar.
It does. It's canceled.
Yeah, we're going to reset it for now to March 8th, but obviously Mr. Wingo won't be on it. So we'll be in touch if we find other old jail cases of yours to see if you're open for business on March 8th. Yes, sir. Be safe. Thank you. Thank you, Ms. McCauley. Now you can for real go away.
Judge, I have a question about that March 8th trial calendar. Is that going to be the same trial calendar from January 11th, just whittled down, or is it going to be additional cases are going to be added?
Both. So anything that was not resolved, and I'm happy to say almost half of the Jan 11 calendar was resolved, but anything that wasn't, will give the judges an opportunity to roll it over. There may be some who say, no, I've had second thoughts, I don't want to do that. But anyone who wants to keep the cases on may do so. And then we're going to reopen it to let the other judges know, if you think you're ready and comfortable by March 8th, that's our next target date. Can we pull it off then? Don't know, but we're going to try. So,
can I ask another question?
But it will be limited to 2 cases per judge with roughly the same parameters, no multi-defendant cases, probably no CWAC cases. Not because we have anything against them, but we need to.
They're more difficult.
We just need jury selection to be as undramatic as possible.
Gotcha. That's what I figured. I just wanted to make sure that there weren't any CWAC cases on there because we're doing a lot of moving, a lot of transitioning going on up here. So, and I know we aren't going to be fully staffed by then. So I just kind of want to get an idea. Do you think you're going to let us know about the cases that are going to be on that calendar?
It'll be a while. I have not sent out the email. Ms. McKee from our court admin office and I are sort of the point people. And I have yet to send out the email to the bench saying, if you want to add things, here's how it's going to work. Our goal is to publish the calendar by early February.
Okay, I was going to ask for at least 30 days.
Yeah, and ideally, it shouldn't be a big, well, I guess the surprise factor is judges don't know which ADAs are going to be in a courtroom. It shouldn't be a big surprise factor for the defense attorneys because ideally the judges are soliciting cases from the defense attorneys. They need to be willing to roll. You know, if a public defender in courtroom X says, I'm not comfortable doing an in-person trial, then that judge isn't going to have a trial for a little bit.
So all the trial line people have been assigned. There, at least every courtroom has one person assigned. Just the special units don't have people assigned yet.
Oh, so it's not going to be the case that there are two